Welcome to Law 2023 Online Residential Property Shape the Debate with me, David Keighley, and Richard Snape. Today's Q&A is scheduled to last for around 1 hour, and we'll cover your pre-submitted questions. So, introductions about myself. I was admitted as a solicitor in 1980, and until my retirement for full-time practice, I was a partner in and head of residential property at a legal 500 firm. I now use my extensive experience and understanding of residential conveyancing to cut through the academic niceties and make things relevant for the busy practitioner. I, amongst other things, am a contributing editor to the Law Society Conveyancing Handbook. My sessions for Law 2023 Online were the new shared ownership model lease and the Building Safety Act, leaseholder protection and lenders requirements. Richard has been the head of Richard Snape's been the head of professional development, professional support, at David Jones Bowles since 2002. He speaks at numerous courses for law societies all over the country, various public courses, in-house seminars within solicitors' firms, and has also talked extensively to local authorities and central government bodies. His areas of specialism include both commercial and residential property, in particular in relation to local government law, conveyancing issues, development land, commercial property, and encumbrances in relation to land. His sessions in respect of Law 2023 were key issues affecting easements and restrictive covenants in freehold land. So let's have a look at some of the pre-submitted questions we've received from you. And obviously Richard and I will comment on these as far as we can. So the first question is, again, is directed at the Building Safety Act, and you won't be surprised to know that a lot of the questions have been submitted are relating to the Building Safety Act. So the first one is, can a company registered as a registered proprietor be a qualifying leaseholder under the Building Safety Act 2022? Well, I suppose the answer to that is probably yes. If the company is again, the company, there's no specific mention of companies in the Act, but of course, a company is a separate legal entity, and provided it meets all the other qualifying criteria, such as only had the one property or had no more than 3 properties, then I suspect it can. I think there was some suggestion that you needed to be an owner-occupier. But there's been some rowing back on that from some guidance issued by government, which basically suggests that you don't need to actually have lived in the property in order to qualify, as long as you were registered as the owner, etc., on the 14th of February 2022. So possibly is the answer to that. So Richard, have you got?
Yeah, I think that's well, there's been a lot of rolling back on the whole of the Building Safety Act. It is the most disastrous, well, leaseholder protections part 5 is the most disastrous piece of legislation I've ever come across, and they've missed a lot of things like that. As you mentioned, I mean, the company probably, I think almost certainly can be a qualifying leaseholder, with the one obvious proviso that it can't have a principal home. Yeah, and if it's got, like you mentioned, if it's got more than 3 dwellings throughout the UK, not just flats but dwellings, and not just in England, then it won't be a qualifying leaseholder, which is, a lot of buy-to-lets are held through companies, Yeah. To save on income tax, it's a sort of between, more stamp duty, land tax to be paid, but less income tax. Yeah. And it's one of many things I suspect they just didn't think about because they rushed.
Well, indeed. I mean, it seems a rather major omission to not sort of clarify that companies can qualify. As you say, a company can't physically live in a property. I mean, it might have it as its registered office, but it doesn't mean it's living there. But I think the requirement to actually physically occupy the property on the 14th of February 2022 appears to not be an issue. So on that basis, possibly yes.
Well, they missed a lot. They missed executors out, didn't they, as well?
Indeed, yeah. I mean,
not even obvious bare trusts and discretionary trusts.
Yeah, all sorts of things. So, I mean, one of the comments I had in some of my conversations with civil servants in the relevant department was that when I was questioning about the interpretation and why things weren't clear in the Act, their rather unhelpful comment was, well, ultimately, if there's a problem about issues about interpretation, that will be for the courts to decide, which is of no use to our clients. We say,
Yeah,
I can't give you the answer, but we could find out by going to law. It'll take
well,
about 3 years and cost you.
Well, the savings on your leaseholder protections would be far outweighed by the cost of it.
Indeed, yeah, indeed. So anyway, there we go. So I think the answer to your question is yes, we think probably subject to the usual qualifications about number of properties, etc., etc. So the next one was, how should we deal with the landlord certificate provided under the Building Safety Act if it is not fully completed? Good question. There is, as far as I'm aware, no specific guidance or clarity on that point at all. My gut reaction is to say that go back to the landlord and say, you have a statutory obligation to complete this form in the prescribed format. Fill it in properly, please. Yeah, how do you tell
the alternative is that they might just lose the ability to charge for safety work if it's not properly completed.
That may be, yeah, again, but it's not equally clear, is it? I mean, it's they've provided one. It doesn't say in the legislation it has to be a completed or properly completed one. It just says they have to provide one if they don't provide one. But then we've got an issue with the form itself. Says in it that if the landlord doesn't provide the document, then they're deemed to meet the contribution condition and or be liable. But that's not what it says in the regulations. The regulations don't lock out a landlord from providing a certificate at a later date if they haven't provided one on the first instance. I mean, government say that their interpretation is that it does, but I think the problem is that the regulations say that the landlord has to provide a certificate on each of the trigger events. And if they miss out on one, does that mean they can't provide it if another trigger event happens? Again, we don't know. It would have to be for a court to determine, but I would hope that a court would look less favourably on a landlord that's trying to game the system by saying, well, I didn't provide it when I should have done, but I'm now coming back at a second bite of the cherry. And you've got anything to add to that, Richard? Yeah,
well, I mentioned just before we started the shape the debate that it's October the 6th today, and then this morning's LexisNexis, there was a decision called first tier tribunal decision, so not setting a precedent, but Willen G&O. And there was a case somewhere in the Rise late last year that said the same thing, that where the landlord just refuses to provide the certificate, the tribunal doesn't think it's got any jurisdiction to do anything about making them. And if the landlord meets the contribution condition, or the landlord's associated with the developer, they're going to have to, they can't charge for safety work anyway. And they can apparently just refuse to give anybody the landlord certificate. I've also come across quite a few landlords this last couple of months who are using the old landlord certificates because they changed on August the 5th. And I've started doing private client Building Safety Act courses because of things like executors and the likes. And a frequent question I get there is who gets to sign the certificate. The leaseholder's deed of certificate and like, if the leaseholder's incapacitated in the power of attorney and the likes, can you sign on behalf of, because it's not made clear, that's the leaseholder deeds of certificate, or if there's a court appointed deputy or something like that. We need to just start all over again with the Building Safety Act leaseholder protections.
Yeah, it would be a good idea.
Give it some proper. We could do courses all over again on it, David.
We could do, yeah. We could repeal the act and write it properly, and we could rewrite all our material and start all over again. Yeah, so it's the gift that never stops giving, isn't it? But I think you're right. I mean, it seems bizarre, isn't it, that the courts or the tribunal, can't force somebody to comply with a statutory obligation, but that's one of the perhaps less surprising issues about the deficiencies in the act. But anyway, carry on. Next question is again about the Building Safety Act, which is, have government made any progress in amending the Building Safety Act in respect of lease surrender and regrant? Well, what I'm about to tell you couldn't make up. Is essentially that there was a bill tabled before the House of Lords, which did include various amendments in relation to the Building Safety Act, but one in particular in respect of lease surrender and regrant. It proposed to make the basically said that a lease that had been surrendered and regranted or varied would remain a qualifying lease, and that any leases which had already been surrendered and regranted would retrospectively be considered as qualifying leases. So effectively, it was making the provision retrospective. The amendment was passed by the House of Lords, but astoundingly, this was a government motion, but 145 government peers voted against it and argued against it in the debate. So, as it stands, we appear to have a government motion to correct the drafting error, which doesn't have government support. So it's a bit bizarre, but it's now going to the House of Commons, where I understand it will be voted on in the House of Commons on the 17th of October. So we'll have to wait and see what happens. I have seen a number of articles published recently which say that the issue about leasehold extensions has been resolved and gone away. That is not true. Yeah, as I say, it's still working its way through Parliament. And I fear a little bit for, if the government opposed it in the Lords, are they going to oppose it in the Commons, and why did they oppose it in the Lords? I do have the Hansard transcript for the debate, and I poured through it, but I can't see anything that is obvious, although maybe they don't like the retrospective application, but they drafted the thing, so it seems bizarre that they're voting against their own amendment, but we'll wait and see what happens in the Commons on the 17th of October.
Yeah. Well, yeah, they just seem to just crog it. It was a good idea, actually, just to crog it onto the, part of the levelling up and regeneration bill.
Yeah.
And obviously, back in late April, it was, wasn't it, when they changed their guidance, when they finally admitted the problem that they hadn't thought of leasehold extensions and, surrendering re-grant and tens upon tens of thousands of leaseholders since February the 14th last year have lost their protections. And why on earth they don't think it's a good idea to just change that in legislation is beyond me. I mean, they were originally saying, this was always my theory, they were saying they were going to introduce legislation in the next parliamentary year, which starts next month in November. And one of the pieces of legislation they're talking about is a complete reform and overhaul of lease extensions and enfranchisement. So I suspect their plan is to introduce it into that legislation. But that's, that's at least a year away, People need to know, and they've not made it clear if any changes are going to be retrospective or not. So we'll have to see what happens on October the 17th, and hopefully common sense prevails. Yeah,
well, you'd hope so, but I fear for that, I'm afraid. So we'll have to wait and see what the MPs make.
Yeah, I think the idea that in the guidance, if the landlord won't introduce clauses giving you the same service charge caps, you're supposed to report the landlord. And it's not the landlord's fault, It's sort of, it's the Department of Levelling Up's terrible drafting of these things.
And so basically, Michael Gove wants you to write to him and tell him all about it. Well, I'm not entirely sure what he's going to do about it.
He's going to turn up and sort the landlord out, probably with his Excel bully by his side. But the landlord's doing nothing wrong.
Yeah.
I have actually heard stories of people actually writing to the Department of Levelling Up complaining about the landlord not changing the lease and giving the service charge caps, and they've heard nothing.
Yeah, indeed. Yeah. My only thought was that they were using it to gather information and evidence to support the amendment, but if they vote against it, I don't know. It's bizarre.
That thing in September, the House of Lords shenanigans was just beyond my comprehension.
Yeah, no, indeed. Okay, there we go. Right. So next question is, it's not about the Building Safety Act. So this is one directed at you, Richard. So what is the difference between an easement and a way leave?
Yeah, well, they're often used interchangeably, especially in the utilities and the likes. Way leaves are not property rights, they're contractual, basically. They're usually for a fixed term and the likes, and they don't bind third-party purchasers, and they often are used by the utilities. I mean, not so much for residential, but sometimes if you're dealing with things like communications equipment, it's a whole different game. But if you're talking about sort of I don't know, electricity lines going across your garden and things, if it's a way leave, it's not binding on third parties, contractual or third party. They've usually got notice periods as well. You can serve notice. If it was non-domestic, then the utilities can claim necessary way leaves. They can basically insist on a way leave. But if it's domestic, you know, if it's residential dwelling or garden, well, it's going to be a residential dwelling, that doesn't apply. So that's basically it. The easements are property rights and subject to, well, various things, registration or being overriding interest, they will bind third parties. And that's basically it.
Okay, I think that's covered it. I can't add anything useful to that. So yeah,
I've seen so many, especially surveyors, who call things way leaves as a matter of course when they're easements.
Yeah, indeed.
And there's a massive difference between the two.
It'd be interesting if the plan to make estate agents give full details of all easements and restrictive covenants, etc., on memos. If they, you know, how they're going to cope with way leaves and things is beyond me. But
I don't think that many people would be able to cope with easements.
Well, no, there is that. Yeah,
what is and what isn't an easement is another question, you know.
yeah, indeed.
An easement to use the neighbour's toilet, that's my favourite.
Yeah, true. Yeah. There was one that a case I did years ago where somebody claimed a right of easement to open a toilet window to allow the air to escape into next door's garden, and claimed an easement of necessity. So quite what they were doing in that toilet.
I'm not sure it's an easement. I'm not sure if it is an easement. I'm not sure it's an easement of necessity.
Yeah,
but no, Miller and Emser products. I remember it using the neighbour's toilet. That doesn't mean to say I should tell people who, you know, looking in, that you don't automatically have a right to use a neighbour's toilet. It's possible as an easement, but don't go bursting into the neighbour's house and insisting on using their toilet tonight. But yeah,
okay.
You probably haven't got an easement.
Probably not. Okay, right. So next question, again directed at the Building Safety Act. Do you know why the 14th of February 2022 was chosen as a relevant date for qualifying leases? Well, apart from thinking it's a sort of a bizarre Valentine's present to conveyancers, I'm not entirely sure. No, I mean, I have to say I don't know. I know there was an announcement. Michael Gove made various announcements on the 14th of February 2022, so it may well be that the date was chosen to coincide with those announcements. But what the logic or why that particular date was chosen, I have no insight at all. It's just a date that appears to have been plucked out of the air. I suspect it's linked in some way to the fact that the department made various announcements on that date. But why that date was chosen when the Act itself didn't come into force until June, so why it was chosen a date before the Act came into force, it's really unclear, unless you've got any insight to that.
Well, it could be that Michael Gove's just a very romantic man and chose Valentine's Day. Not as romantic as
in our newspapers columns.
Not as romantic as Matt Hancock, though. But he was probably busy in some reality TV show. But my understanding was it was when they produced all the draft changes.
Yeah.
The problem with the legislation is that it had gone through the House of Commons. It had all but gone through the House of Lords. Michael Gove was reinstated as the Secretary of State for Levelling Up and decided he'd change everything at the last moment. And as I say, my understanding, that's the day, February the 14th last year, was the day they produced the draft changes. Yeah. And they were saying that they chose this particular date, you know, the day they published the draft changes, because they didn't want people to manipulate the market. And it's had the exact effect, you know, of manipulating the market. You know, once you're not a qualifying leaseholder on February the 14th, 2022, you aren't forevermore. And again, that's another sort of crazy piece of legislation. You know, you and your successors, you might have somebody who was, you know, it was their principal home, and you know, they're qualified leaseholder on February the 14th, 2022, and they're now selling to an investor with 1,000 properties, and that investor's a qualifying leaseholder, and how that doesn't manipulate the market is beyond me.
But, as I say, I think the 14th, as you said, the 14th of February, the date of those regulations, and so effectively, the announcements by Michael Gove. So but why the date was the 14th of February chosen for the announcement?
I really don't know.
You don't know.
I don't know why they well, apart from the fact that that was the date they published the draft changes.
Yeah, and so why they chose that date to publish them again, we
So
just don't know. So
when the legislation receives the roll assent on April the 28th, and it comes into force, the leaseholder protections anyway, on June the 28th. The landlord certificates and leaseholder deeds certificate didn't come into force until July the 20th, 21st.
Yeah.
You know, and how on earth were you supposed to comply in the interim? They didn't even exist.
No, indeed. Okay. Fine. Okay, so let's move on. Next one is again for you, Richard. When will the land registry register a prescriptive easement?
Well, this will take the rest of the session. It's notoriously difficult for the registry to, to get the registry to register prescriptive easements. Basically, it should be, and I won't go into massive detail, rights to light and more recently, rights of access should be different. But rights of light aside, because you can claim rights of light as prescriptive easements after 20 years, unless they're enjoyed with written agreement. It's with around forced secrecy and permission and the likes. Everything else historically, after 20 years, what the land registry would do is give you a claimed easement. The person next door is claiming an easement by prescription, based on 20 years user as of right. And a claimed easement is, you can't rely on, you couldn't report to a purchaser or a mortgage company, everything's fine, they've got a claimed easement. What you want is an indefeasible easement on your title. And historically, the land registry, it's not the law, but the land registry have always wanted evidence of 40 years user as of right for that. And because of various issues in relation to vehicle access and access rights generally, some years ago, they did change the practice guide and you can base prescriptive rights of access on 20 years user as of right. But don't blame me if no one's told people at the land registry that's the case. You've then got to show it's without force and it's without secrecy and it's without permission and the likes, which is not an easy thing to do. I think I mentioned in my little talk, it's definitely in the notes you've received, that the idea that you require 40 years user for indefeasible easements emanates from the Prescription Act of 1832. If you can trace a piece of legislation that's worse than the Building Safety Act, that's probably the last piece of legislation in history in 1832 it is. So there are other ways of claiming prescriptive rights, not least of which is lost modern grant. It's a legal fiction. You were granted an easement by deed in the past and you've lost the grant, and that's based on 20 years user. And you should always be able to claim lost modern grant on 20 years user. It's also the case under the Prescription Act and what the land registry rely on. It's got to be the 20 years, 40 years next before some suit or action. You've got to make the claim. You've got to be using the right before you make the claim. Whereas lost modern grant, all you need to do is show 20 years user. You might not get anywhere in the land registry, but 20 years user at any time. There was a case, it's in the notes, I think I might have mentioned it in the webinar, but that's quite a while ago, called Hughes, and they benefited the encumbrance of Frampton-on-Severn, Arlingham, Frechern and Framlingham in Saul, not necessarily in that order, which made that quite clear. You don't have user for 40 years, you don't have user for the 40 years before you make the claim, just 20 years in the past, and that's enough. I say, but whether you get anywhere with the land registry on that argument is another matter. I don't know if you want to add to that at all.
No, I think that's probably covered everything, Richard. It's, as you say, the land registry are notoriously a law unto themselves in many respects. Be nice if they knew what they were doing sometimes, but
I suppose that, the other thing to mention is that if you contact the land registry, we want an easement, based on 20 or 40 years user as of right, and we got the statements of truth and all this kind of stuff. They'll approach the landowner you're claiming against, and if the landowner says yes, you'll have your easement eventually. If the landowner says no, they'll go to arbitration, and if there's a sale in the offing, you can forget about that. And frankly, the best thing to do if you've got long user, I suspect, if there isn't a dispute, by the way, active approaching the land registry and the land registry approaches the landowner, you've got a dispute. And if there isn't a dispute, I think it's best sorted out by an insurance policy, quite honestly.
Yeah, no, good point. I mean, yeah, I'm sure many of us don't really like using insurance policies if we can avoid it, but it's yeah, there may be some circumstances when it's better to take that route than stir up a potential harm.
Yeah, as long as your client is aware that the insurance policy, if the worst happened, doesn't allow you to get to your house, it allows you to claim off the policy and the cost and the lost value.
Yeah,
I think it can be the quickest way of solving problems.
Yeah, indeed. Okay, no problem. Okay, so let's press on. Next one is again the Building Safety Act. If a seller did not own the property on the 14th of February 2022, can they insist that the previous owner provides a leaseholder deed of certificate? No. Basically, the lease in that situation, the leaseholder is required to complete, the current leaseholder is required to complete the form to the best of their knowledge, but that of course would require them to realistically make attempts to establish contact with the owner who was the owner on the 14th of February 2022 to establish the status of that owner. But if the owner refuses to play ball, or for example, if the owner has since passed away, then and you can't find out, then I suppose it's really a question of the leaseholder, the current leaseholder, just completing the form on the basis of the best of their knowledge, and perhaps making it clear in the form that it's completed on the basis of the best of their knowledge. But it's there's no way. I mean, if the tribunal can't force a landlord to provide a current landlord to provide a certificate, I'm not sure quite how, if anybody, could ever force somebody who is no longer an owner of the property to provide the certificate now. I mean, this is going to be an issue. I mean, inevitably, there are going to be a lot of people who bought properties last year between the 14th of February and the 28th of June when the Act came into force, who bought properties when there wasn't a requirement for a leaseholder certificate, who, when they come to sell in a few years' time, are going to be faced with the need to provide a certificate based on information relating to a time before their ownership. And yeah, it's going to be a problem, and it's something which is a bit of a going to be an issue and become more of a harder and harder issue the further we get away from the 14th of February 2022. So it's just one of those unknowns and uncertainties in relation to the Act. The practical application of the Act has has brought about this rather unsatisfactory situation.
I mean, it's not just it's a problem already. There was so much conveyancing going on in 2022. Huge numbers of people must have sold the properties. Who were the leaseholders on February the 14th, 2022 must have was sold. Before the certificates came in late July.
Yeah.
And lots of, how many people weren't sending in, filling in leaseholder deeds of certificate last year and even this year? Huge numbers. And I think the guidance from the government, or the suggestion from the government, is that you should approach the previous owner and get the information from them. Well, good luck to you on occasion.
Yeah.
And you're going to have people who are 2 or 3 times removed from the qualifying leaseholder on February the 14th.
Yeah.
You're going to have to start thinking about, I suspect, getting historic official copies and things like this.
It is going to be. It is already a problem, and it's going to become an increasing problem.
And you've got the problem again of the sort of the more unusual situations. What if like you mentioned, what if the person who was the qualifying leaseholder on February the 14th last year is dead?
Yeah.
What happens if they're incapacitated? What do executors do if executors? I'm coming across executors just refusing to have anything to do with the forms on the basis, just like inquiries, that we don't know because it's nothing to do with us.
Yeah.
And I suspect they're going to be in breach of trust if they don't fill in the forms.
Well, so yeah, the answer to the question is, can you compel somebody? Well, the answer is no. You have to approach them and hope that they're willing to play ball. Assuming you can find out assuming you can find them in the first place. It's not necessarily going to be. Obviously, you'll be able to find details of the previous owner by getting backdated office copies, but that's not going to tell you where that person's living now.
No.
And their contact details. their solicitors might know, but again, the solicitors can't be compelled to provide the whereabouts of their client.
Well, solicitors would have to get the client's consent, wouldn't they?
Indeed, yeah. So it's fraught with difficulties, that one, I'm afraid. Okay, so moving away, next one. How much light is someone entitled to receive through their windows? So that's for you, Richard. It's an easement point.
Yeah, well, that's another 2-hour course. I know there are lights, sort of rights to light specialist surveyors who would know a lot more about the detail than I ever would. Yeah, basically, I mean, you've got easements to light, and say easements to light are dangerous because they're almost always prescriptive through long use, 20 years usually, unless enjoyed by written agreement. And they have to be through a defined aperture, which to you and I is a window. You've got the general right to light on your garden. But how much light you're entitled to depends on what you're doing on the land. Some people say there's a 45-degree rule. If you block the light at more than 45 degrees, it's actionable. That's not so. It depends so much on the facts. The test is what's left enough to reasonably enjoy the land, not what's taken away, but is what's left over. And I say, if needs be, you need to get specialist advice. It's not just about big tower blocks and the likes. There's lots of issues in relation to people building extensions and the likes. If it's a residential property, you need more light than an office that's artificially lit all day in the city centre. If it's a warehouse, you probably don't need much light. I think I mentioned in my talk that Allen and Greenwood, where there was a greenhouse receiving light for 20 years through the greenhouse to the greenhouse, and that stopped somebody building. They got an injunction against somebody building a fence nearby on the boundary. So something like a greenhouse needs lots of light. That's the best way of stopping development near you, a greenhouse or two. 20 years later.
I think I've seen a report about, it's not windows, but a report that there is no right to light to a solar panel. So that's
There's always been, people have asked me over the years about things like solar panels, and I suppose the other one people were asking me about a few years back is polytunnels. So the mind boggles, but I mean, in the world of residential, certainly, sort of what's left over is that a reasonable amount. When I say you need to be able to get specialists, one of those things that does cause sort of neighbour disputes. People hit on the idea as a way of stopping people building the extension at the back of their house and so on. But we say it depends so much on its facts.
Okay. Right, I think we can move on. Next one, again, another one about the Building Safety Act. If there are multiple landlords in a block of flats, which one is required to provide the landlord certificate? Well, according to the regulations, it's the current landlord. And the current landlord in the regulations is defined as the person who is a landlord of under a qualifying lease. So my interpretation of that would be, if you've got multiple landlords, it's going to be the one that sits directly above the individual leaseholder, because there'll be the landlord under the qualifying lease. That's certainly, let's say, that's my interpretation of it. I've certainly seen or heard of instances where multiple landlords are all refusing, saying it's not my responsibility, it's somebody else's responsibility. You should do it. But ultimately, I think it's the only definition say is current landlord, the landlord under the qualifying lease. So I can't see how it can be anybody other than the landlord sitting immediately above the residential owner. Now that landlord, of course, then if they issue a landlord certificate to the qualifying tenant, then that landlord's got to provide documents, copies of it to all the other landlords. But that's a side issue. That's an issue for them to deal with, not for you or I as the conveyancer for the purchaser to deal with. But I certainly think that would be my interpretation of it. So I don't know if you've got any comments.
No, I think it's not 100% clear, but it must be the immediate landlord.
Yeah.
The landlord under that particular lease. But I wish they'd made it clear.
Yeah.
I mean, somebody was asking me about it in a course I did only a couple of days ago, actually. That very question, because they got a head landlord and an intermediate landlord. The intermediate landlord was a residence management company. They didn't own the freehold, obviously. That was the head landlord, because it's different if it's a residence management company holding the freehold. And so basically who gets, the head landlord was saying this is nothing to do with me. So basically the leaseholders under a different guise are having to provide the landlord certificate, because they're the residence management company.
And the regulations say not clear, because it does say the landlord who's the landlord under a qualifying lease of the building. So but it's again, I think we can only see, our interpretation is it's the landlord immediately above the residential owner, but the regulations are
I've come across problems as well with the something different than leaseholder protections, but the Part 4, the higher risk residential buildings, where you have to have an accountable person and the likes, and the principal accountable person if you got more than one. And the principal accountable person is the person with an interest in possession or responsibility for repair and maintenance of the exterior. And I've come across situations in big blocks where you don't know who the principal accountable person is. And again, it's not quite as bad as the leaseholder protections, but again, disastrously drafted parts of the legislation. We don't even get onto how you find out the height of a building.
Well, yes, I was having a discussion about this at a course I did yesterday. So,
I was talking to a surveyor about it. Because the surveyors are starting to say we won't tell you whether the building is 11 meters or 5 stories in height. And why is this? Because it's not a lawyer's job to don your hard hat and jacket and get the scaffolding out and measure it. It's apparently because the government's guidance, the surveyors think, is not clear as to how you measure, and they're waiting for the Royal Institution of Chartered Surveyors to give them guidance, and they're just refusing to tell you what the height of the building is.
Oh yeah, the government's guidance or the definition is, of course, that it's measured from the lowest point on the ground to the top of the floor slab of the top residential property. Well,
it's a sort of counterintuitive. It's measured to the bottom of the top floor, if you like.
Indeed, but effectively, you've got to, you'd probably need access to the top residential property in order to determine where its floor slab ends.
That's what the surveyors are basically saying, and the guidance is not clear as to how you measure from the bottom of the bottom floor, and all these kind of things. If it's a mezzanine floor, it counts as a story if it covers more than half the widest part of the building.
I find it amusing that they, amongst other things, that there's so many uncertainties, but they did find time to define what a mezzanine floor is, and that counts. But
they do say the legislation is like that, though, isn't it? Little snippets of things they've obviously thought about in detail, but the really significant stuff they've forgotten about.
I know. I was talking to a delegate on course the other day who said that the clients are having to pay £1,000 to somebody to physically go out and measure the height of the building, because the managing agents and the management company are refusing to give them the information. And they're at an impasse, so they need to know. I mean, it's thought to be under 11 meters. It's apparently only 4 stories. So the 4 stories, it's less than 5 stories. So the critical thing hinges on the height of the building from that down to the ground. But it's the government. I know there was something mentioned in a conference in the summer where government said it's not expected to be the responsibility of a conveyancer to measure the height of the building, but ultimately the lenders impose requirements on their mortgages based on relevant building, which is height and all stories. So it does fall to some extent at the desk of a solicitor.
I tell you what I really wish, which really annoys me, is I wish Barclays in their Part 2s would learn how to spell stories. Well,
yes, would be good, wouldn't it?
But like a work of fiction, which is quite apt, actually.
Indeed, but then ultimately it's not expected to be the role of the conveyancer, but the bottom line is it lands on your desk, and it's not our responsibility. We're not qualified to go out and measure buildings. It's something to refer to somebody else. And he's saying the surveyors are refusing to do it, then well, who do you refer to? Well, I'm sorry.
Okay, I came across one where there were 2 different blocks, where one was less than 5 stories and less than 11 meters, but the neighboring block was well over. But they had a connecting corridor between the 2. And if it's a connecting corridor, unless it's some emergency exit, it's one building. And they were swearing blind we didn't need to provide landlord certificates and so on. They probably did. There's a definition of what the building is, which is quite complex as well.
Indeed. Okay, so let's move on. Next one again for you, Richard. How can positive covenants be enforced in freehold land?
Well, that's another one for 3 hours. Have you got 3 hours on your hands? The answer is that, well, basically, it's one of the most disastrous cases in the whole of property law, one that people do at their degree level studies. Degree in Oldham Corporation in 1885, that basically said positive covenants in freehold land are not property rights, and therefore don't bind third-party purchasers. They're purely contractual. Incidentally, if the government wanted to do something useful, they would introduce a piece of legislation that, you know, be a bit longer than this, but it says that positive covenants bind third-party purchasers in freehold land. You still need a management structure and the likes, but that's the main reason why you've got so many leaseholds when people are living together in blocks. Then the best easy way, and there are problems with it, is direct covenants and restrictions. You know, when I come to sell, you know, it's like maintenance and the like, maintenance of private roads. When I come to sell, I can be required, because I've got a contract with the, you know, with the original party. I can be required to require my purchaser to enter into a deed of covenant with you, and it's backed up with a restriction. You can't become registered proprietor unless you agree to the deed of covenant. I say it's still got problems attached to it. Well, quite a few problems attached to it, but that's the best easy way. I suppose the one that there's been a movement back towards those this last few years, but the other one is that was used commonly as estate rent charges. And we've still got the question mark over whether something is definitely an estate rent charge or not, which is a topic in its own right, quite frankly. But because of all the problems that Section 121 of the Law of Property Act caused, if you don't pay your money on time, you know, there's a right to, you know, basically put a lease on your property. Estate rent charges are very much out of favour. I can understand fully why. I mean, again, forget about things. There's a need for the Building Safety Act. You could obviously see that. It was sort of, you know, well-intentioned legislation. But they ought to actually do something about Section 121 of the Law of Property Act.
Yeah, that would certainly be a help, wouldn't it? But okay, so let's look at the time. Let's crack on. The next one's quite interesting. Has the Law Society issued any guidance relating to the Building Safety Act? Well, the Law Society has issued a document which contains some words. Let's put it that way. It does not contain guidance. It is basically just a document saying that they're aware of the problems and are lobbying to try and get changes to the lenders' requirements and to the Act, and that the burdens being placed on solicitors by lenders' requirements and others are disproportionate and not capable of realistically being dealt with by solicitors without taking on what the Law Society say was an unacceptable level of risk. So the document did not contain any practical guidance as to what should be done, other than it was just basically saying that, yeah, we're aware of the problem and we're trying to do something in the background. But guidance, no. Indication that they're trying to do something, yes, but no further news on whether they're going to be successful, or indeed whether the lenders really care, or whether the Law Society are going to have any real traction on this. So no guidance really. We're still very much on our own, which is interesting. I mean, the CML UK Finance entry does say, the Part 1 entry does say that, you know, solicitors might want to take account of any guidance issued by the professional body. Well, yeah, it would be nice if we had some, but as it stands, no, we haven't. So, have you got any thoughts on that, Richard?
Yeah, I mean, I think just that 5.14.17 of the Lenders Handbook says you should take into account guidance, and there is no guidance.
Yeah.
In terms of the mortgage companies, I'm not sure the mortgagees want to actually, or some of them want to actually lend on high-rise leasehold. Myself, I mean, there's one or two mortgagees where I personally wouldn't want to act. Shall I name them?
Well, I think probably people know who they are.
One starts with B and the other starts with N.
Yeah.
But yeah.
Yeah. Okay. All right. No problem. So next one is again for you, Richard. Is a restrictive covenant abandoned if no enforcement action is taken, and if so, after how long?
Well, the answer was no. I mean, the most obvious way. Well, sorry, get this the right way round. It's Hepworth and Pickles, isn't it? And the famous Hepworth and Pickles, 120 odd years ago. Hepworth and Pickles was actually a commercial premises where various restrictive user covenants against, primarily selling alcohol had been breached openly for 24 years. And after 24 years of open breach selling alcohol, it was held that the covenants couldn't be enforced. I can think of other cases from a similar time period that say 15 years and 25 years and so on. It seems that Emmett and Title just seem to round everything up to 20 years, and the UK Finance Lenders Handbook picked up on that and basically says if the covenant's been openly breached for 20 years, you don't have to do anything. You can certify everything's fine, but otherwise take out insurance. There's an argument that under the limitation periods, under the Limitation Act of 1980, that if it's by deed, then after 12 years of open breach, it's unenforceable. And that's a strong argument. If I was reporting to a lender, I'd have to rely on, I think, the 20 years. But if certainly of 20 years open breach, the covenant's not enforceable.
Okay, yeah, I think you're right. So, yeah, based on the handbook is the probably the 20-year point, but yeah, again, it's difficult to know, as you say. But there we go. Okay.
If the mortgagee say 20 years, if you're reporting to the mortgagee, I think it's got to be 20 years.
20 years, yeah. I think.
And if the other side, it's got to be an open breach, obviously. But if an extension or something like that, and the consent to alteration covenants is an open breach, and if the other side, most conveyancers will accept that argument. If they don't, I think they should pay for the policy.
Yeah, indeed. Okay, fine. So next one, again about the Building Safety Act. What is the position in Wales as regards to the Building Safety Act? Well, that's an interesting one. As I was faced with a seminar in Wales recently, including the Building Safety Act, and I said to the delegates, if I'm going to talk to you about the Welsh aspects of the Act, this will take 10 minutes, because at the moment the Act is not enforced, or the leaseholder protection aspects of the Act are not enforced in Wales. The Act applies to England and Wales, but the Welsh government have been given devolved authority to determine when the provisions come into force, and at this stage they have not taken that decision. The indication is from a question that was asked in the Welsh Parliament. Was Mark Drakeford, the leader, basically said that indicated that they were not going to bring the leaseholder protections into force because it would be the government themselves that would take action against the developers. But so as it stands, leaseholders in Wales do not have the same protection, albeit defective protection, that the leaseholders in England have. The only bits of the Act which are coming into force in Wales are in respect of the fire safety requirements and the responsible person, and they came into force Sunday last, the 1st of October. So as it stands, the Act realistically, as far as everyday conveyancing is concerned, is not relevant or not yet in force in Wales.
Yeah, I was talking to some people from the sort of Cardiff area about it on Monday on Zoom. I've got to go and talk about it in Swansea a couple of weeks from now. It's general conveyancing update, but including that, and it's very difficult to know what to do. As you said, I mean, most of the legislation applies to England and Wales, but the Welsh government were given delegated powers to decide the height of the building. We're also given delegated powers to decide the height of a higher risk building. In England, it's got to have at least 2 dwellings, 18 meters or more, or 7 or more stories. They have decided on the height of the building in relation to the design of the building and the construction of the building, which doesn't affect conveyancing, but not the occupation of the building. And as you said, the indications earlier this year in the spring from Mark Drakeford, the Welsh minister, was they didn't intend to bring it in. He did say that Wales hasn't got the same problems with blocks of flats, comparatively new blocks of flats as England's got. He's obviously never looked out of the Welsh Assembly building to see what Cardiff's like nowadays. Nothing but right down the bay as far as Penarth. And the Welsh government would pay for the work anyway, and they haven't got the money.
No, okay.
So no one has a clue what the future holds.
No, indeed. So it was a degree of uncertainty, should we say, in Wales. So, okay, just looking at the time, I'm looking at the questions. I think we'll take something which is not the Building Safety Act and not easements, because we've not covered the anything to do with the shared ownership section. So I'm just looking down through the questions and pick this one out. If my client is buying a new build shared ownership flat, can I insist that the lease is granted using the new version? Well, the answer to that is no, unless the funding that the housing association are using to fund the development of that property was granted to them after the 1st of April 2021. If it was in the 2021 to 2026 funding cycle, then yes, they are required to use the new lease. But if the funding was not granted in that funding cycle, so is using funding granted, say in 2020, then yeah, they're perfectly entitled to use the old lease. So yeah, the answer is no, you can't insist unless the funding was granted on that particular date. But quite how you know when the funding was granted is another matter. But yeah, I think the point, perhaps relevant point here, is that this lease has been around now for a couple of years, but is only just really beginning to appear in the wild because we're only just now getting to the stage where developments agreed and funded in April 2021 are probably just now coming to the stage where they've been built out and properties are being sold. So yeah, if you've got question marks about it, then yeah, raise the questions. I would understand that a housing society might prefer to use might prefer to use the old lease because the requirements imposed on the housing association by the old lease are considerably less onerous than they are in the new lease. But yeah, it's really the question is linked to the funding date on which it was granted rather than the date on which the lease itself is actually being granted. So again, I don't know, shared ownership is not your forte, Richard. Do you want to add anything on that?
I've dabbled.
Oh yeah,
yeah. Remember once one of my favourite inquiries was on shared ownership leases where they didn't provide any evidence of staircase on a subsequent sale. And so you raise inquiry, please provide evidence of any staircase, and then the response came back that it's a ground floor flat.
Yeah.
But they, I'm dabbling. Yeah, I talked about shared ownership. No, I think you're quite right on it. I mean, the one thing I have seen is that in the same development, a mixture of old and new model shared ownership leases, which is not a bit of a nightmare to sort of manage.
Yeah, indeed. Okay, no problem. Okay, well we've got other questions, but we're running out of time. So yeah, thank you very much for watching the Law 2023 online residential property shape the debate. And so that's all the questions we've got time for. Please don't forget to join the solicitors group Law 2023 online community on LinkedIn to continue the debate and to be included in exclusive offers for future events. If you have purchased the online course, there's still time to watch the pre-recorded content. Your expiry date will be displayed next to the webinar itself. And for those of you that haven't, there's still time to buy the complete event, including a recording of this session. To book, you just go to www.thesolicitorsgroup.co.uk, where you will also find the online exhibition. The exhibition is open to anyone to visit, and if you book the entire package, you can claim your 1 hour free CPD webinar from the webinar learning catalogue, which is apparently worth £35 plus VAT. Finally, after viewing the online course, please complete the feedback form that's available in the related links section, and you'll receive your CPD certificate via email. Please don't be too nasty about me and Richard. We are quite sensitive souls at heart, really. Anyway, but thank you again. Thank you very much for listening, and please have a great day. So good afternoon, good evening, good morning, whatever it is to you, wherever you happen to be watching Richard and I. So thank you, Richard, and yeah, thank you everybody for listening to our ramblings.
Okay, thanks a lot.